As we all know, a negotiable instrument means an instrument which is in writing, containing an unconditional promise. It may be promissory note, undertaking, it may be in bill of exchange, an unconditional order in the case of a check, signed by the drawer, signed by the maker, signed by the drawer, directing the drawee in the case of bill of exchange, but in the case of check, it is always directing the banker to pay a certain sum of money to or to the order or to the bearer of the instrument we have seen. So therefore, negotiable instrument is said to be negotiated when the party transfers it by way of mere delivery or by way of endorsement and delivery. An instrument is said to be negotiated. Instrument is said to be negotiated when it is transferred. There are, we have referred to in the previous class, there are even the presumptions. When the instrument is said to be negotiated, what is implied is that it is negotiated by one person to another person to another person for consideration. When the instrument is said to be negotiated, then the transferable, when the instrument is said to be negotiated, when it is transferred from the drawer to the payee. From payee to further, he can endorse. Payee can endorse, he becomes an endorser. Endorser to the endorsee. How? By way of delivery or by way of endorsement and delivery. Transfer by way of delivery or by endorsement delivery is one of the essential characteristic features of negotiable instrument, as we have seen. And in the beginning also we have defined the word negotiation. Negotiation, an instrument is said to be negotiated when the instrument is said to be negotiated. An instrument is said to be negotiated when, I will just get you what we have referred to earlier. An instrument is said to be negotiated when one of the party to the negotiable instrument, like transfers or negotiate from one person to another person. As such, negotiable instrument is a document in writing which entitles a person under the document. A negotiable instrument is a document in writing which entitles the person who has acquired the document for consideration in good faith and without defective notice. It entitles that person who has acquired that document to a sum of money which a negotiable instrument represents. That is one meaning. And it is negotiable. Why? It is transferable from one person to another. How? It is negotiable because it is transferable from one person to another. And how it is transferable? Either by delivery or by endorsement and delivery. Therefore, it is a device which would operate for deriving money payable on it. It is a device which is operable It is a device which would operate for deriving money payable on it, on any of the negotiable instrument. Remember, when it is payable, negotiable instrument is a device. You are negotiating it, transferring it from one person to another. Correct? Either by way of delivery or endorsement and delivery. Therefore, it would be considered as a device, a mechanism by which would operate as a payment of the amount mentioned in the instrument. In order to get the payment, there is a requirement that it is to be presented. In the case of promissory note, in the case of bill of exchange. What is presentment as such? What is presentment? It has to be presented either for acceptance or for payment. A negotiable instrument is required to be presented by whom? By the person in possession of the instrument. You understand? It may be endorsee, it may be payee, payee, or when the payee further endorses, it may be the endorsee, and they are required to the party who is in possession, holder. He is required to present it for acceptance and payment. But whether it is both, in the case of promissory note, he is required to present it for payment. In the case of bill of exchange, the holder is required to present it for acceptance and then again present it for payment. And in the case of check, he is required to present it to the banker. That's it, for payment. Banker should pay on demand. Banker should pay the amount mentioned it when the amount is there. When the amount is there, which is insufficient to honor the check, then he can dishonor it. Okay, he can refuse the payment under it. So what do you mean by that? Actually, this presentment as such. Presentment means showing the instrument to the drawee. Showing the instrument to the drawee in case of bill of exchange. Showing the instrument to the drawee. Showing the instrument to the acceptor in the case of bill of exchange, or showing the instrument promissory note to the maker for the purpose of acceptance and payment. So in other words, when the instrument is issued, the holder in possession of it, he will have to show, he will have to present it, he will have to show the instrument to whom? He will have to show the instrument, showing an instrument to the drawee, to the acceptor, to the maker for acceptance or for payment. Is it not? As the case may be, for acceptance or for payment, as the case may be, and that is known as presentment. A Negotiable Instrument Act classifies presentment of negotiable instrument under the three kinds. A Negotiable Instrument Act classifies, divides the presentment of negotiable instrument under three kinds. One, presentment of bill of exchange for acceptance under section 61. Another one, presentment of negotiable instrument promissory note for sight. And three, presentment of negotiable instrument for payment. Requirements for one is presentment of bill of exchange for acceptance. You have to be presenting to the presentment of bill of exchange for acceptance under section 61. You will have to present it, Mr. Holder or payee, you will have to, or endorsee, you will have to present it to the drawee for the purpose of acceptance. Okay, and the presentment of promissory note for sight and presentment of a negotiable instrument for payment under section 64. Okay, the requirements of valid acceptance are follows. The requirement for the valid acceptance are the following. One, acceptance must be on a bill of exchange and it must be in writing by writing the word accepted. Acceptance on a bill of exchange must be in writing with the word accepted. Okay, and that writing of the word accepted must be across the bill, on the face, on the back, or with the signature of of it with the signature of the drawee as such. There are three parties: bill of exchange, drawer issued the bill of exchange, drawee thereby directed to pay the amount under the bill of exchange, which bill of exchange represents, and the payee. Okay. Payee can further endorse it, endorsee. Okay. Anyhow, this payee or endorsee, if it is endorsed, he is required to submit to the drawee, who may be a banker or any other person, as mentioned in the instrument, to the drawee for first it has to be presented for acceptance. But all these to be done before maturity of the instrument. All these to be done before the maturity of the instrument. And when it is shown, when it is submitted to the drawee for acceptance, the drawee will, when it is submitted for acceptance, the drawee will sign across the bill of exchange, either on the face or on the back of the instrument, bearing the signature of the drawee. Until the drawee signs the bill, he is not bound, he does not become the party to the instrument. Until the drawee signs the bill, he is not bound under that, and he does not become the party under the negotiable instrument. The bill may be signed by the drawee or by his duly authorized agent. Okay. Okay. Right. There are various rules that are required there. After acceptance of the bill, it must be delivered to the holder. Okay. And the various rules for valid acceptance is that presentment with regard to, and the bill of exchange has to be presented to the drawee before the maturity. And second, the drawee upon receiving that bill of exchange for acceptance, drawee on his drawee is not expected to, he is not bound as such. But if he signs, then he should sign on the face or back of the instrument, and then it must be returned to the holder. Then the presentment with regard to the time and place of the acceptance. When a bill has specified that it must be presented at a particular time, then it must be presented at that time. Where the presentment for acceptance is not the bill must be presented before maturity, that is clear. And what is the place? If the bill that is accepted specifies the place for when the bill which specifies the time within which it has to be presented, then it must be adhered to by the payee or endorsee. When the bill of exchange specifies the place at which it is to be presented to the drawee for acceptance, then the payee or the endorsee shall comply with the same, and it must the payee or the endorsee shall present the bill at that place. And then if the bill is not presented by the holder or whoever, whether it is payee or endorsee, he is the holder. If the bill is not presented for acceptance by the holder, when it is obligatory on his part, then the drawer and all endorsers are discharged from the liability. That is very much important. Okay, a holder must allow drawee 48 hours to consider whether he will accept the bill or not. That is another requirement. So as far as the rules as to accept presentment for acceptance is concerned, this happens in the case of bill of exchange, as I said. Okay, and it must be presented to the drawee named therein. It must be presented before maturity, and drawee, if he desires to accept, then accept it, but give him 48 hours of time. To whom? To the drawee, whether he is going to accept or not. And if he decides to accept, he must sign across the instrument, either on the face or on the back of the instrument. Then it must be presented within the time, if at all time specified by the drawer in the bill of exchange, that the holder is to present within particular time, present it within that time. And the place, if the drawer has specified the place wherein it has to be presented by the holder to the drawee for acceptance, then it has to be complied, adhered strictly. And if the bill which is required to be presented to the drawee for acceptance, if the bill which is required to be presented to the drawee for acceptance, if it is not presented, then it would discharge the drawer and all endorsers from their liability as such. You understand? From their liability. If presentment, when it is excused, presentment of bill of exchange is excused in the following cases. 1. If the drawee cannot be found after a reasonable search. Understand? Presentment for acceptance is excused when if the drawee cannot be found after reasonable search. 2. If the drawee is dead or becomes insolvent. 3. If the drawee is a fictitious person or an incompetent person, presentment for acceptance is not necessary. Then, in case where the presentment has been irregular and acceptance has been refused on some other ground, yes, presentment is not. Then presentment for acceptance is excused when the bill is treated as dishonored. When the bill is treated as dishonored, then presentment for acceptance is excused. So when we have referred to what are the rules regarding to presentment for acceptance. The rules regarding the presentment for acceptance consists in about 7-8 rules I have stated. When it is excused, yes, it is excused if a drawee is not found after reasonable search. 2. If the drawee is dead or insolvent. 3. If the drawee is a fictitious person or incompetent person, presentment is not necessary. And then when the presentment for acceptance is excused, the bill is treated as dishonored. Okay, bill is treated as dishonored. As I said, sometimes there may be delay in presenting the bill, which may, due to reasons beyond the control of the holder, then it may not be on account of his default or misconduct or negligence. In such circumstances, the delay may be condoned. That is also there. Okay, when the bill is required to be presented for acceptance, and if there is any delay which is not delay due to reasons which are beyond the control of the holder, or there is no misconduct or negligence on the part of the holder, then the delay may be condoned. Delay may be condoned as such. The drawee may still be accepting the same. Right? Now, under section 64, you will find rules as to presentment for payment. Presentment for payment is necessary in the following cases: maker, drawee or acceptor. Remember, intentionally prevents the presentation of the instrument. Okay, presentment of bill of exchange is when the presentment for bill of exchange is necessary, we will discuss a presentment for bill of exchange for payment. Pronote, bill of exchange or a check must be presented for payment to a maker, to the acceptor, to the drawee by the holder according to the directions contained in the instrument. The pronote, bill of exchange. Now I am talking about the rules regarding presentment for payment. The promissory note or a bill of exchange or a check is to be presented for payment by the by whom? By the maker. The promissory note, bill of exchange or a check is to be presented for payment to the maker. In the case of promissory note, the drawer, or if the drawee has signed their bill of exchange, to the drawee, and to the banker, the drawee in the case of check. They are to be presented for payment to them or to any of them, as the case may be, by the holder according to the directions contained in the instrument. If there is a default in presentment for payment on the part of the maker, if there is a default for making the presentment for payment to maker, drawee or the banker, as the case may be, on the fault of the holder, then the parties are not held liable as such. They are discharged from the liability. What are the rules relating to presentment for payment? 1. Presentment for payment. There are about 6-7 rules. I will just quote one by one. Presentment for payment must be done in the usual business hours. 1. Presentment for payment must be done during the business hours. 2. Presentment for payment during business hours. Presentment for payment must be made during the usual business hours. And second one, present when the bill is payable at a specified period after the date or after sight, then in such case bill must be presented at maturity. When the bill of exchange is payable at a specified period after the date or after sight, then it must be then in such cases must be presented before the maturity. 2. A bill must be presented for payment on the third day after the date fixed for the payment of each instrument. Okay. Why? For example, in the bill, if it is mentioned like 60 days, bill is payable within 60 days. It means it is entitled to 3 days of grace. Therefore, bill becomes payable on the third day after the expiry of the period of the bill. After the expiry of the period of the bill, the third day it becomes payable. It could be payable as such. Okay. Even if it is on the third day, if it is presented, you are entitled to. Even if one installment not paid, that you leave it as far as a bill must be presented. It says, why I said leave it. It says a bill must be presented for payment on the third day after the date fixed for payment of each instrument. Even if one installment is not paid, then it has the same effect as non-payment of a note at maturity. Then a bill of exchange must be presented at a place mentioned in the bill. So there is a need. What is that? 1. It must be presented during the usual business hours. Second one, it is entitled to 3 days of grace. Therefore, it could be presented for payment even after the date specified, but on the third day of the bill, after the expiry. Then 3, it must be presented at the appropriate place, okay, as mentioned in the bill. Then fourth one, a check must be presented at the bank upon which it is drawn before the relationship between drawer and banker gets altered. A check must be presented to the banker. A check must be presented to the banker upon which it is drawn before there is any change in the relation between the drawer and the banker. It may be possible that the drawer has issued the check to me, and a check is valid for 3 months. You know that. And what I did, I did not make the payment. In the meanwhile, the drawer, he closed the account. He closed the account. Drawer has closed the account. Okay. In which case, what happens? Me, the payee or holder of the check, I credit the check issued by the drawer to my bank. When the banker sends to the paying banker, my banker is collecting banker. When my banker sends it to the paying banker, that is drawer's banker, he says that account closed. That's what I said. That when the check is to be presented to the bank upon which it is drawn, before there is any change in the relationship between the banker and that of the drawer as such. Okay, that is very much required. A bill or other form of negotiable instrument payable on demand must be presented for payment within the reasonable time. A bill or other form of negotiable instrument which is expressed to be payable on demand must be presented within the reasonable time, and presentment for payment can be made to the duly authorized agent of the drawee as such. In the case of bill of exchange, presentment for payment could be made to the duly authorized drawee, to the duly authorized agent of the drawee also it is possible. It need not be submitted to the drawee only who has accepted. It need not be submitted to the drawee who has accepted the bill. It could even be submitted to the agent who is authorized by the drawee as such. And then delay in presentment for payment will be excused if such a delay is due to the causes beyond the control of the holder, okay, or due to no fault of negligence or omission on the part of the holder. So therefore, delay as far as the presentment for acceptance could be excused. We have seen in the bill of exchange, if it is not due to the situations which are beyond control. If it is due to situations beyond the control, or if there is no misconduct or negligence on the part of the holder. Likewise, this is also applicable. Okay. Then here also applicable. Delay in the presentment for acceptance, we have seen the delay in presentment for payment could also be excused if the delay is caused due to reasons which is beyond the control of the holder, or there is no misconduct or default on the part of the Therefore, these are all rules regarding the presentment for acceptance and presentment for payment. I repeat, the presentment for acceptance, it has to be presented to the drawee before maturity. Okay, one, it has to be when it is presented for acceptance, the drawee shall sign on the face or on the back of the instrument. Okay, and then he must deliver it to the holder. Right? Then there are other what is that? It could be one more time when it is to be presented for acceptance for to the drawee. If the time limit is specified, adhere to. Then place, if the place is specified, adhere to. Then if the bill is not presented by the holder, when it is obligatory on the part of the holder to do so, then all the drawer and the endorsers are discharged from the liability as such. And we have also seen the presentment for acceptance rules. Presentment for payment must be made in the usual business hours. Then when the bill is payable at a specified period after date or site, then it must be, in such cases, the bill must be presented at maturity. The bill must be presented for payment on the third day after the date fixed. For payment of each, bill must be presented for payment on the third day after the date is fixed, for payment in the instrument. That means a bill of exchange is entitled to 3 days of grace. 3 days of grace after the period fixed for the bill. After the expiry of its period. What is the period? Usually a bill is valid for a period of 90 days. And when a check is valid for a period of 90 days, means it is not entitled to any days of grace, but a bill of exchange is entitled to days of grace as such, and even promissory note would be entitled to 2 days of grace. Okay. Then if a check is not a check must be presented to the bank at which it is drawn, but before any change in the relationship between the drawer and the banker as such, a bill or negotiable instrument payable on demand shall be presented for payment within the reasonable time. And lastly, the presentment for payment can be made by the holder even to the duly authorized agent of the drawee as such. Okay, and as I said, delay in presentment for payment could also be excused. Could be excused if the delay is caused due to such event which is beyond the control of delay is caused to such event which is beyond the control of the holder, or if the delay is not due to the negligence, not due to default on the part of the holder. And lastly, if the bill is accepted by the drawee which is payable at a specified bank, okay, if the bill is accepted by the drawee and payable at a specified bank, then the banker should pay the holder. These are all the rules relating to presentment for payment and presentment for acceptance. Now we will move to the next part, that is endorsement and kinds. What is that endorsement? There are we will now refer to the meaning of endorsement, and then we'll refer to their kinds. As I told you, the negotiable instrument, one of the greatest feature of negotiable instrument is negotiability or transferability from one person to another person. Correct? And we have seen that transferability of negotiable instrument could be either by delivery or by endorsement and delivery. Okay? Negotiable instrument could be transferred or negotiated either by delivery or endorsement and delivery, so as to constitute the other side as the holder, endorsee thereof. Okay, right. What do you mean by how this endorsement, negotiable instrument could be transferred from what is that called, from drawer to the payee. Negotiable instrument could be transferred from the transferor to the transferee, from drawer to the payee. Okay, how? It is called from holder to the further. A negotiable instrument could also be transferred by way of endorsement. There could be any number of endorsement, but before the maturity. All these endorsements shall be done before the maturity as such, and it can be transferred any number of times. No restrictions. Okay, and then how it is transferred? Either by mere delivery or by endorsement and delivery. What is by endorsement? Okay, suppose if the bill is transferred, bill is said to be bill is negotiated from A to B. Now B becomes a holder. Okay, B becomes a payee. B becomes a holder. This holder can further transfer it. The payee or the holder can become endorser, and the payee from him, person, the transferee from the endorser becomes endorsee. And if the endorser further desires to transfer it, then endorsee becomes an endorser. Okay, endorser. Then from endorser, whoever gets it is called endorsee. Remember, like this it can proceed, it can go on. So a negotiable instrument can be transferred either by way of delivery or by way of endorsement and delivery. What is the meaning of endorsement? It is said endorsement means writing or signing your name either on the face of the instrument or on the back of the instrument or on a separate piece of paper called allongee. Okay, A-L-L-O-N-G, allongee, for the purpose of negotiation. Section 15 it says. What is the meaning of endorsement? Endorsement means signing your name on the face of the instrument or on the back of the instrument, or if there is no space available, in a separate sheet called allongee for the purpose of negotiation. Okay, so the very meaning of transfer of instrument by way of signing on the face or a back or on a separate piece of paper called allongee for the purpose of constituting the other party as a holder thereof, who can in turn endorse, who can in turn endorse the same instrument. It is up to him to decide. But I said, what is the meaning? How it is affected? How endorsement is affected? The holder, the payee, if he desires, he can negotiate the said instrument further. If it is negotiable, all negotiable instruments are negotiable. But if the very instrument itself forbids further negotiability, then it cannot be negotiated. But otherwise, instrument could be negotiable any number of times before the maturity. As I said, 1, 2. How it is negotiated? Either by delivery or by endorsement and delivery. What is that endorsement? Right? Signing the name on the face of it, writing the name on the face, writing the name of the person on the face of the instrument, on the back of the instrument, or on a slip of paper called elongi for the purpose of negotiation. The instrument is said to be negotiated by endorsement. The party endorsed it known as endorser. Party to whom it is endorsed is known as endorsee. Right? And the requirement of valid endorsement. See, there will be, this question is frequently asked in the examination. Define endorsement. What are the rules regarding valid endorsement and explain its kinds? Okay. Now I have defined the endorsement. Now what are the rules as to valid endorsement? First one. Endorsement must be on the instrument itself, and if there is no space there, then on the endorsement could be either on endorsement must be on the instrument itself, either on the face or on the back. And if there is no space on either on the face or back, then it will be on a separate slip called elongi, right? So therefore, at any cost, endorsement must be there in the instrument or in an annexed sheet. Then signature of the endorser on the instrument is very, very crucial. Signature of the endorser. As I said, to constitute endorsement means writing the name of the person. Who is he? He is called endorser. So signature of the endorser upon the instrument is essential. Such signature may be made without additional words. Right? Next, endorsement could be made by the endorser either by signing his name on the instrument or by specifying in addition to his name, specifying in addition to his or her signature, the person to whom or to whose order the amount under the instrument becomes payable. Person to whom or to whose order amount mentioned in the instrument to be paid. That also could be mentioned. Endorsement could be made by the endorser either by signing. Endorsement could be made by the endorser either by signing his or her name on the instrument or by specifying an additional word, by specifying in addition to his or her signature the person to whom or to whose order the money under the instrument should be paid. This is also another. And fourth one says, any endorsement by the endorser is not complete unless it is delivered to the endorsee. Any endorsement when it is done, as I said, any endorsement when it is done by the endorser will not be complete unless it is delivered to the person in whose favor that endorsement has been effected. That is essential. Okay. So therefore these four are requirements of valid endorsement. 1. Endorsement must be on the instrument itself or on the slip or on the back, or if there is no space on the slip, as I said, elongi. Then signature of the endorser is essential. Then endorsement could be made by the endorser either by signing his or her name on the instrument or by specifying in addition to his or her signature the person to whom or to whose order the money becomes money under the instrument should be paid. And lastly, fourth, the endorsement by the endorser is not complete. In order that any endorsement by the endorser to be complete, then it is to be delivered. Therefore, any endorsement by the endorser is not complete unless it is delivered to the endorsee, the person to whom it has been made. Now, let us refer to these 5 main kinds of endorsement. What are they? The 5 main kinds of endorsement, as I said, one is blank endorsement, another one is full endorsement, another one is partial endorsement, another one is restrictive endorsement, another one is conditional endorsement. Conditional endorsement is again divided into sans recourse endorsement, sans phrase endorsement, facultative, okay, facultative endorsement, and contingent contingent endorsement. Likewise, there are mainly 5 kinds, like blank, full, partial, restrictive, conditional. But conditional is again divided into 4: sans recourse, sans phrase, facultative, and contingency. Contingent. What is that? Contingency endorsement. Now let us mean all these. What in by blank endorsement? A negotiable instrument may be endorsed by the payee or holder, who is entitled to it with the signature on the back of the instrument. With the signature, a negotiable instrument may be endorsed by the payee or the holder, who is entitled to it with his signature on the back of the instrument, with no instruction or direction specifying the name of the person to whom the payment is to be made. This is called blank endorsement. You understand? The holder or payee in possession of the instrument, the holder or the payee who transfers by signing their name, the holder or payee who transfers the instrument endorses the instrument by signing his name, his or her name, without specifying as to whom the instrument is to be transferred. That is, endorsee's name not mentioned. Okay, this is called blank endorsement under section 54. A blank name of the endorsee not mentioned. That's it. Okay, I can tell you that when the endorsee's name is not mentioned, then when it is transferred, whoever subsequently to whom it is transferred, he can also do the same thing, because the blank instrument could be, it cannot be further endorsed. Remember, it cannot be further endorsed. Which one? Suppose if the holder endorses without specifying the person to whom it is endorsed, but that person has received it, if that person who is now in possession, if he is to endorse further, then endorser's name should be there. Very clear. Okay, right. Otherwise it cannot be endorsement. Otherwise from that person only it will be deemed that it is endorsement. It is said to be endorsed, like that. You got it? Therefore, in case of blank endorsement, the endorsee's name not found. Right? The endorsee can later fill it. No problem. But everything else there. Then what is called full endorsement? When the order check is signed by the person concerned on the back of the check, directing to pay the amount mentioned in the instrument to a specified person, then the endorsement is said to be full endorsement. When the order check is signed by the person, who is the person? That is the drawer. When the order check is signed by the person, that is the drawer, on the back of the check, directing to pay the amount mentioned in the instrument to a specified person, the instrument is said to be endorsed in full. Okay. When the order check is signed by the when the order check issued by the drawer to the payee, when the order check is signed by the drawer to the payee, okay, and that payee signs on the back of the check directing the amount specified in the instrument, the payee now signs on the back of the instrument directing this amount to be payable to the specified person, the instrument is said to be full endorsed in full. The instrument is said to be endorsed in full. Say for example, there is a drawer. In the case of a check I am talking about, A has issued a check to B. Okay, and who is the drawee? It is C, the banker. C is banker. In the case of a check, the drawee must always be banker. When A issued a check to B, then B is the payee. Correct? B sign and it is an order check. It is an order. Pay B rupees 5,000, like that. When that B only on the back of the check signs his name, directing this amount to be paid to Mr. D. It is stated, when an order check is signed by the person concerned on the back of the instrument, directing this amount to be paid. What amount? Say for example 5,000. Directing this amount to be paid. When Mr. B signs on the back of the instrument, directing the amount to be paid to Mr. D, then the instrument is said to be negotiated The instrument is said to be negotiated from B to D by endorsement. What is that kind of endorsement? That kind of endorsement is called full endorsement. Okay. Then we have got restrictive endorsement. That is another one. Okay, partial endorsement. When the check or bill is for a larger amount, but the payee or the holder is entitled for the instrument. When the check or bill is for a larger amount, but the payee or holder entitled for the instrument makes the instrument on the back of the instrument for a lesser sum. You understand? Though the check or bill is for a larger sum, but the payee or the holder entitled for the instrument makes an endorsement on the back of the instrument for a lesser sum. You understand? I will now give the example regarding the same. Say, a bill of exchange may be a bill of exchange is for the payment of rupees 10,000. Correct? And it is drawn by A and it is transferred to C. There will be one person drawee. He will pay, right? Under the bill of exchange there are three parties: drawer, drawee and payee. Who is payee? C is the payee. I am now explaining the partial endorsement. When partial endorsement is effected, when C the payee or the holder, when C the payee or the holder who is entitled under the instrument makes an endorsement to E, this is important, by signing his name on the back of the instrument. You understand? When C, the person who is entitled under the instrument for 10,000, when he makes further endorsement, when he endorses further to Mr. E, but not for this 10,000, but for only 7,000, okay, by signing on the back of the instrument, the instrument bill of exchange is said to be negotiated from Mr. C to E. This not for 10,000 rupees. The bill of exchange, the negotiable instrument actually represents 10,000. But now it is delivered to Mr. C. Correct? Mr. C would be entitled to get 10,000. But what happened? Mr. C further endorsed it by signing on the back of the instrument, but for a lesser sum than 10,000. Then it would entitle the endorsee from C. C is the holder. C is the endorser. C is the payee. He further endorses the instrument not for 10,000 but for 7,000. This is called partial endorsement. Okay, a partial endorsement is not valid for negotiation. Okay, but where the balance amount has been partly paid, in addition to the already part paid sum, a note to that extent shall be endorsed. A note, if the, suppose, actually this partial endorsement is not valid for negotiation, correct? Because the bill of exchange represents, full value, 10,000. Then when Mr. C, the holder or the payee, when he further endorses on the back to Mr. E, but only for a lesser sum, then what about, this is called partial endorsement, right? But partial endorsement cannot be valid as far as negotiation is concerned. But if there is a note, in the bill of exchange that rupees 3,000 had already been paid earlier, so if such a note is contained by the endorser while making this partial endorsement, then it may be valid, correct? And then fourth one, restrictive endorsement. Restrictive endorsement happens. Negotiability of the instrument may be prohibited or restricted. This is known as restrictive endorsement. Negotiability of the instrument. Further negotiability of the instrument may be prohibited or restricted. This is called restrictive endorsement. Okay. In other words, when B signs a negotiable instrument payable to bearer like this, pay the contents to C only, then it should be paid to C only. Okay. Pay C for my use. Pay C for my use. Then it is restrictive endorsement. Pay C or order for the account of B. Okay, pay C or to his order for the account of B. Again, it is restricted. Okay, that is why I am telling you that negotiability or transferability of the instrument is prohibited or restricted is known as a restrictive endorsement. The holder of such an instrument is restricted from further endorsing the instrument. Correct? The holder of such an instrument is restricted or prohibited from further endorsing the instrument is the main feature of restricted endorsement. And lastly, we will go to conditional endorsement. What is that conditional endorsement? When the instrument, when an endorsement is made on the back of the instrument with instructions that the amount covered under the instrument should be paid subject to certain conditions or subject to the limitations or qualifications, then it is known as conditional endorsement. Okay, I will get to this only. A had issued a bill of exchange to C, and the drawer is Mr. D, correct? But there is a condition to be fulfilled by Mr. C. C would be entitled to the payment only when it is fulfilled. I mean, only rather, C is the holder. If C further negotiates to Mr. E, now we are talking in terms of endorsement is concerned. A, C, D. A is the drawer, D is the drawee, C is the endorsee, and C further endorses it in favor of E. Okay, and C becomes the endorser, E becomes the endorsee, but subject to a condition. You understand? Subject to certain limitation or qualification or condition. What is that condition? Okay, it says that I will tell you. Pay Mr. Bharat or order on his marriage with Vijaya. Pay Bharat rupees 5,000 or order on his marriage with Vijaya. It's a conditional. Okay, that's what it is said. An endorsement could also be conditional. When the endorsements are made, on the back of the instrument with the instructions that amount covered under the instrument should be paid subject to fulfillment of certain conditions or qualifications, then it is said to be a conditional endorsement. Okay, while restrictive endorsement places restrictions upon further negotiation, a conditional endorsement limits or negates the liability of the endorser. A restrictive endorsement restricts or prohibits the further negotiations, whereas conditional endorsement imposes certain conditions or limits the liability of the drawer as such. Okay, where the endorsement is qualified or conditional, it is known as conditional endorsement. Such conditional endorsement could be divided into sans recourse, sans phrase, facultative, contingency. What is that sans recourse? Where in the case of sans recourse endorsement, if the endorsee finds the amount covered under the instrument is not paid, then he cannot proceed. Against the endorser. Where the endorser, say for example, Mr. C happens to be the endorser. He endorsed in favor of E. While making this endorsement itself, he has endorsed with a clause. Sans recourse means without recourse to the endorser. That means when the endorsee makes, when the endorsee presents it for payment, if it is not presented, then Mr. Endorsee cannot make the endorser liable. The endorser has transferred it, negotiated to endorsee, subject to no liability, subject to the exclusion of liability. Okay, right? It can be mentioned like this: pay A or order without recourse to me. Pay A or order without recourse to me. See, I am the drawer. I am the endorser. You understand? I am the endorser. I have endorsed it to Mr. A. Like this. Pay A or to his order without recourse to me. Without recourse, when it is stated sans recourse, without recourse, sans recourse, you are prohibited from getting back to me. You are prohibited in inflicting any liability under the instrument on the endorser. So endorser's liability is excluded in the case if endorser endorses to endorsee subject to that condition, subject to that limitation, subject to that qualification, right? It is sans recourse. What is it? Sans phrase endorsement. In this form of endorsement, the endorser does not want endorsee or any subsequent holder of the instrument to incur any expenses on the account of the endorser. In the form of sans phrase endorsement, the endorser does not want the endorsee or any subsequent holder to incur any expenditure on the account of the endorser. Understand? In the case of a sans phrase endorsement, the endorser does not want endorsee or subsequent holders to incur any expenditure on the account of endorser. So, endorser has excluded any expenditure to be incurred from his account or on his account under the instrument henceforth. So, he has excluded, sans phrase. This type of endorsement is called, sans phrase means without expense, it is said. Then we have got, facultative endorsement. What is that facultative endorsement? Endorser does not want the endorsee or here in this case of endorsement, by express words. In the case of a facultative endorsement, by express words, the endorser abandons his right or increases his liability under the instrument. It is possible in the case of facultative endorsement, when the endorser, Mr. C, when he endorses to E, while endorsing so, either he may abandon his right under the instrument, or he may increase his liability under the instrument. Who? Mr. The endorser C as such. He may either abandon any of his right, or he may increase his liability. I will get you one example. An endorsement reads like this: pay Lalit or order. Pay Lalit or order rupees 5,000. Notice of dishonor is waived. Notice of dishonor waived. This is the pay Lalit or order rupees 5,000. Notice of dishonor waived. It means he could be made liable. He doesn't need to send a notice of dishonor. He doesn't need to send any notice of dishonor to C so as to make him liable, because he has abandoned his right, or he has given up his right, okay, or he had increased his liability. When C has endorsed the instrument to E, E becomes an endorsee, E becomes a payee, E becomes a holder. When he presents it for payment, then you would be entitled to get the payment, no doubt. But what happens, sometimes if the said instrument is dishonored, as the very endorsement reads, how it reads? Endorsement reads like, pay Lalit rupees 5,000 or to pay Lalit or his order rupees 500 or 5,000. Notice of dishonor waived. So when it is dishonored by the drawee while presented for payment, then Mr. E may be required, in general circumstances, C may require E to serve a notice of dishonor to make him liable. But Mr. C, the endorser, while making the endorsement itself, he has excluded that. Notice of dishonor is waived. Therefore, E can straight away make C liable without giving any notice of dishonor as such. And lastly is, what is that? Contingency, endorsement. Sometimes endorsement may be made on the instrument by the endorser. Sometimes the endorser may make endorsement wherein the liability for payment may depend upon the happening of a specified event. Correct? This is called contingency endorsement. When C, the holder, endorses it, when the a bill of exchange is drawn by A to C, C, the holder, payee, can further endorse it. Okay? And while endorsing, he included a condition that the amount mentioned in the instrument becomes payable to the endorsee upon the happening of an event. Okay, this is called contingency endorsement. Sometimes the endorsement may be made by the endorser, wherein the liability of the endorser may depend upon the happening of certain event, and that event should happen, otherwise the endorsement goes, otherwise the liability of the endorser will fail. That's it. Okay. Therefore, this is what the case. So I have discussed with you what is the meaning of endorsement, what are the features of valid endorsement, and explain the different kinds of endorsement. There are 4 features of endorsement, as I said, namely endorsement on the must be on the instrument itself. If there is no space on the face of the instrument, then on the back. If there is no space on the back, then on the separate sheet called along it too. Second one, signature of the endorsee becomes very essential. Signature of the endorser becomes very essential. Okay. Such a signature may be made without additional word or with additional words. Then endorsement must be, endorsement could be made by the endorser either by signing his name on the instrument or by specifying in addition to his name certain person to whom it becomes a certain person or to whose order the instrument should be paid. Then lastly, endorsement. Any endorsement by endorser is not complete. Any endorsement by the endorser is not complete unless it is delivered to the person to whom or to whose favor it is made. In order that an endorsement to be complete, it must be delivered to the person to whose favor, to whom it is made. And these features of valid endorsement could be easily, gatherable when we learn to understand the meaning of or types and further types of the main type. Blank endorsement. What is a blank endorsement? Name of the endorsee is not mentioned. What is full endorsement? Full endorsement dealing with the, when the order check is signed by the person concerned on the back of the check, directing the amount mentioned in the instrument to a specified person. When the order check is signed by the person concerned on the back of the check, directing to pay the amount of the check to the amount of the check to a specified person, then the endorsement is said to be full endorsement. Okay. When the order check is signed by the person concerned on the back of the check, you understand, directing to pay the amount of the instrument to the specified person, the instrument is said to be the instrument is said to be full endorsement. Then we have got partial endorsement. Partial endorsement is not valid unless a note in the, as I said, the bill of exchange is for 10,000. If it is negotiated by way of endorsement for rupees 7,000, then it is called actually the bill of exchange is for 10,000 and it is issued to C. When C endorses it to E, but for 7,000 only, such is called partial endorsement. It is not valid, and it could be valid when a note in the said instrument is contained by the endorser to the effect that the remaining 3,000 has already been discharged, has already been paid like that. Then it is valid. Then we have gone to see restrictive endorsement. Restrictive endorsement either restricts or prohibits a further endorsement. Condition endorsement says that when the endorser endorses the instrument and the endorsee would be entitled to get the payment only upon the fulfillment of certain conditions or qualifications, it is called condition endorsement. They are of several kinds. Sans recourse, when the endorser endorses subject to no personal liability, it is called subject to this clause, he excludes his liability on the instrument, then endorsee cannot make subsequently after endorser endorses it to endorsee, in case of any liability under the instrument happens, endorsee cannot make the endorser liable because he has excluded. Subject to that only it has been transferred by endorser to endorsee. When the endorser excluded his liability, sans recourse means without liability. Sans phrase means without expense. When the endorsement, when the endorser endorses the instrument to the endorsee with the qualification that endorsee or any other person under the instrument should not incur any expense on the account of the endorser, that means it is endorsed sans phrase, it is without expense on the account of the endorser as such. Then we have got facultative endorsement. What is a facultative endorsement? Facultative endorsement where the endorser abandons the right or endorser increases its liability. Okay, it is possible. And then contingency, where endorser endorses it to endorsee, where endorsee would be entitled to get the payment subject to the happening of a contingent event. Yes, it is called what is that? Contingency endorsement. I mean, all these four are different forms of conditional endorsement as such. Let us now proceed to the material alteration as such. What are the different when any alteration could be termed as a material alteration? Under section 87 of the Negotiable Instruments Act, following alterations are material alterations. A change which alters the legal identity or business character of the instrument. A change which alters the legal identity or business character of the instrument, or which may affect the contract of the instrument, is called material change or material alteration. The main effect of material alteration is that it makes the instrument void. Right? A document is said to be materially altered when the entire substance and nature of the instrument is changed. Then such are called material alteration. A material alteration effect is that a material alteration will render the instrument void. Any alteration which alters, affects, changes the legal identity or the business character of the instrument, or which may affect the contract of the instrument, is called any change which alters the legal character, business character, or the contract of the instrument, is called material alteration. It will render the instrument void. The following are material alteration. Any material alteration to a negotiable instrument renders the same negotiable instrument as a void. Okay. One, alteration by endorsee. Any such alteration, if it is made by the endorsee to the instrument, discharges his endorsers from the liability in respect of the consideration thereof. If any alteration is made by the endorsee unilaterally, such alteration will discharge the endorser from the liability. Alteration of date. If a date of the bill is, if the date of the negotiable instrument is changed without consent of the prior parties, it amounts to material alteration. If a check, a bill of exchange, or a promissory note will contain the date. Presumption is that the date mentioned is the actual date of its execution. But if the date is altered by the endorsee, then if the date is altered by the holder without the consent of the prior parties, it amounts to material alteration and it will render the instrument void. And you cannot, you cannot make earlier parties, prior parties liable. Then alteration of time of payment. Okay, say for example, 3 months after date is changed to bill payable 3 months after sight, is a material alteration, correct? Then alteration has to, see, if an alteration is made in the time of payment, that is as to the time of payment. For example, if a bill is payable 3 months after date, is changed into bill payable 3 months after sight, it is a material alteration. See, after date and after sight is different. After date means the date as it occurs in the instrument. After sight means after it is shown for payment. From that date 3 months. See, you cannot. 3 months after date of issue is what the words appears. But if you say 3 months after, instead of a time, if you change it to, alters it to sight, then it changes materially the character of the instrument. Hence, it will render the instrument void. Mr. Holder, if you do it unilaterally, you will discharge. You cannot make earlier parties liable under the instrument. Okay, we have seen alteration by endorsee, anything, alteration as to time, alteration as to date, alteration as to payment. Any alteration regarding the place of payment certainly is a material alteration which will render the instrument void. Alteration as to the sum payable, you cannot change. Alteration as to the sum payable also cannot be changed. Alteration as to the endorsement also. If the words added to a bill of exchange, that blank endorsement, if the words are added to a bill of exchange with the blank endorsement so as to convert them into a special endorsement, then it is said to be a material alteration. And alteration of parties. The addition of a new party to the instrument amounts to a material alteration within the meaning of the section, and therefore if you add any new party, Mr. Endorsee, Mr. Holder, you are not permitted to add any new party. If you add any new party, then it is a material alteration. Okay. If the addition of a new party to the instrument amounts to a material alteration within the meaning of section 87, and it will render the instrument void. But there are some alterations which are not to be termed as a material alteration, namely which the Negotiable Instrument Act itself permits, namely inchoate instrument. See, in case of section 20 of Negotiable Instruments Act, where there is an instrument, incomplete instrument, the holder, when the incomplete instrument is transferred to the holder by the drawer, the holder is authorized under the law to complete the incomplete instrument by adding the necessary details. It will not be called material alteration. You understand? In case of an incomplete or inchoate, INCHOATE, in case of incomplete or inchoate instrument under section 20, the holder is empowered, person to whom it is transferred is empowered to fill the gaps. I mean, he is empowered to complete it. Okay. Then such whatever necessary details he fills, it will be considered not material alteration. Then too, in the case of an authority that is given impliedly to the holder of an instrument which is endorsed in blank to convert into full endorsement, when the holder is empowered to convert a blank endorsement into full endorsement, not material alteration. That is by containing the name of by adding the name of endorsee. You can add Mr. Holder, you can add the name of endorsee. It is not at all material alteration. Then an holder of an uncrossed check is given the authority to cross it, or may convert a general crossing into special crossing. Suppose if a check is given to you plain, there is no crossing, then drawer has issued a check to me without crossing. I am the holder, I can cross it. I can cross it. Uncrossed check becomes a crossed check. No material alteration. 1. If within the parallel lines, no, or just account payee is mentioned, this is called general crossing. Or within the two parallel lines, what I do? Account payee, Canara Bank. This becomes a special crossing. If I do that, it doesn't amount to material alteration. Changing the general crossing into special crossing or uncrossed into crossed check does not amount to material alteration. Okay. Then alteration should change the rights and liability of the parties to the instrument. Material alteration alters the very objective of the if any alteration. So these are the three, as I said, are not at all. When an incomplete inchoate instrument, the holder is authorized under the law to complete the details. It is not material alteration. In case of uncrossed check, it could be crossed by the holder. In case of general crossing, it could be made special crossing by the holder. It is not amounting to material alteration. In case of blank endorsement, could be converted into full endorsement. It is not material alteration. These three are not material alteration. They are permissible under the Negotiable Instruments Act. And then any alteration if changes the rights and liability of the party to the instrument, or any alteration which alters the very operation of the instrument, like date, place, time, sum or rate of interest, etc. If an alteration is effected with respect to these, then it is called material alteration, which would render the instrument void as such. Then we will just refer to now the meaning of noting and protest. What is the meaning of noting and protest? When the instrument, we call it as under section 99 and 100, we call it as when the instrument is presented for payment, if it is not honored, when the promissory note, bill of exchange is dishonored by non-acceptance or non-payment, you understand? the holder may have to take steps to have the dishonor to be duly recorded by a notary public upon the instrument. Right, we will proceed to that. Section 99, 100. Suppose when the promissory note or bill of exchange is presented for payment, okay, presented for payment, and if it is not paid and if it is not paid and dishonored by the party liable to make the payment, the holder, who is the holder? When a promissory note means holder means payee, and the bill of exchange also payee. The holder may cause the dishonor noted by a notary public upon the instrument. This is called when the promissory note, bill of exchange presented for payment by the holder to the promisee or to the drawee, as the case may be, and when the same upon presented for payment, if it is rejected or dishonored, then holder of the promissory note or bill of exchange, as the case may be, they are bound to make the fact of dishonor entered by the notary public upon the instrument itself. This is called noting under section 99 of negotiable instrument. Okay, and therefore what noting contains, very important. This is the proof. A holder may also, within a reasonable time of the dishonor of the note or bill of exchange, get the instrument protested by a notary public. You understand? The holder may also, holder of a promissory note, holder of a bill of exchange, may also, within a reasonable time from the date of dishonor of that note or bill of exchange, gets the instrument protested by a notary public, is known as protest. Notary public will issue a certificate called protest certificate. Okay, we will see that. But now, under section 99, as I said, when the promissory note, bill of exchange is presented for payment, but the drawee or the acceptor, in the case drawee or the promisee has not paid it, and if it is dishonored, then the fact of dishonor may have to be entered upon the instrument itself by the holder upon the instrument. The fact of dishonor may have to be entered by the notary public. This is called noting, and noting consists of the following details. 1. Fact of the dishonor. 2. Date of dishonor. 3. Reasons for the dishonor. I mean, all these have to be entered by the holder upon the instrument from notary public. That is a sort of proof that it is dishonored. When the notary public notes, when the notary public gets it noted upon the instrument, the fact of dishonor, then it is called noting. What are the contents of noting? 1. The instrument is dishonored. 2. When it got dishonored. 3. What is the reason for the dishonor? 4. Reasons as to why the instrument has to be treated as dishonored by the holder. And lastly, 5. Notary charges. What is it? For making that entry on the instrument that it is dishonored, he will write the date, place, cause of the dishonor, etc. He will write all those, and also he will impose some charges for making such a notary charges. So this will be contained. The following are the particulars of noting, namely regarding the instrument which is dishonored when it is presented for payment, then the fact of dishonor. 2. The date of dishonor. 3. The reasons of dishonor. 4. The reasons as to why the instrument is treated as dishonored by the holder. And 5. The notary charges. These particulars, very particulars about these points, these facts will be contained. The fact of dishonor, reasons for the dishonor, the time of dishonor, the reason why the holder considered that it is dishonor, and lastly notary charges. They will have to be contained in the noting. Okay, a noting therefore would contain those particulars under section 99. Okay, yes, the fact that promissory note or bill of exchange has been dishonored is to be authenticated by the notary public prior to giving notice to the drawer to make him liable under that. That is called noting as such. Okay. Now we will go to, in other words, I can tell you the fact that when the promissory note or bill of exchange has been dishonored, it has to be authenticated by a notary public prior to giving notice of such dishonor. In such a case, the notary public has to demand upon the drawer the notary public has to demand upon the maker or the drawee for payment. That is required. The notary public will enter the fact of dishonor on the instrument, not the moment when the holder presents it for present to the promisee or the drawee for payment. But when the holder has presented for the drawee or the promisee for the payment, if it is rejected or refused, then the holder will get the fact of dishonor entered upon the instrument by the notary public. And then the notary public, before making that entry, before making those entries, he will have to issue a notice to the promisee or to the drawee demanding payment. You understand? Demanding payment. If that particular notice is not complied with any positive, if upon receiving notice, if the payment is again rejected or refused by the promisee or the drawee, then Mr. Notary Public will authenticate the fact of dishonor. Mr. Notary Public will authenticate the fact of dishonor by writing these contents in the very instrument itself. What is that? Dishonored, time of dishonor, date of dishonor, reasons as to why it is dishonor, and the notary charges. These will have to be, simply because it is refused or rejected by the promisee or the drawee. You take the instrument dishonored to the notary public. Notary public will not make an entry immediately. Notary public will issue a notice. Okay. By issuing a notice, he has to demand from the maker of the. You understand? You have to demand from the maker of the instrument or drawee of the instrument. I said, what is that? Promisee? No. The promisee, in other words, the payee, he has to submit to the maker, or in the case of bill of exchange, the payee or the holder have to present it to the drawee for payment. If the payment is refused, then the fact of dishonor, so as to get it authenticated in the instrument, then through notary public, a notice for payment of the after the dishonor, a notice for payment may have to be served by the notary public to the maker of the promissory note. This is what? Not to the promisee, to the maker of the promissory note, that is promiser of the promissory note, or to the drawee of the bill of exchange. Even then it is rejected or dishonored, then notary public will authenticate the fact of dishonor in the instrument. As I said, these 4 or 5 factors. Then he will issue a, when the holder desires to have the dishonor of the, when the holder desires to have the dishonor or non-payment of the bill, not only to be noted but also to be certified by the notary public, this certificate issued is known as protesting, and it must be done within a reasonable time. When the holder, upon presenting it for payment, either the promissory note or the bill of exchange, when it is dishonored by the maker or the drawee, the holder not only wants it to be noted, but he also wants to be certified. But he also wants that instrument to be certified by the notary public that it is dishonored. Then it is called protesting, and to that effect a certificate issued by the notary public is called a protest. Understand? The protest is therefore a formal certificate issued by the notary public, duly authenticate the fact of dishonor of the bill or a protest is therefore a formal certificate issued by the notary public duly authenticate the fact of dishonor of the said note or the bill. You understand? This certificate is issued, protest is a certificate issued by the notary public when it is so desired that it is to be authenticated, it is to be certified that it is so desired by the holder. Therefore, protest is a certificate which is the fact of which is a real authentication of the fact of dishonor of the instrument as such. Therefore, what are the contents of the protest? Contents of noting. What is that? Fact of dishonor, time of dishonor, date of dishonor, reason for the dishonor, and notary charges. Contents of noting. What are the contents of protest? 1. The true literal transcript of the instrument. Literal transcript of the instrument should be there. 2. The name of the person against whom and for whom the instrument is protested. The name of the person against whom and for whom the instrument has been protested. 2. 3. The facts and the reasons of the dishonor. 4. The place and time of dishonor are given. 5. The signature of the notary public should also be there. Okay. These are all the contents of a protest as such. But it appears this is not required in the case of a check, because we have provision in the section 138. We will go to that right now. Okay. Right now, before proceeding to what is that? Crossing of checks. Before proceeding to liability of the drawer under section 138, we will refer to crossing of checks as such. Okay. Right. Yes. What are the different, what is the meaning of crossing? What are the objective of crossing? What are the types of crossing? We will just get into that. Okay, right. Date, bank name, pay, signature, number. Okay, this will be like the check format, right? Suppose if this is plain check, understand, I have issued pay Vishal a sum of rupees 10,000 for value received. Okay, signature, I have signed, and the bank name, it's a Canara Bank. Okay, my banker is Canara Bank, and the number, the IFSC code, the MICR code and all will be mentioned. This is what the check. If I lose this, if I lose this, then there will be problems. Especially, what is the problem? It simply becomes a barrier check. It simply becomes a uncrossed check. I mean, now what happens? A person by name Vishal, he is not actually the person intended by me. A person by name Vishal, suppose if he identifies, if he finds this, then he may get the check encashed. It's a wrong payment made, but banker paid it correctly. Payment, it is called payment in due course. Payment, what is the meaning of payment in due course? Payment made by the banker according to the apparent tenor, according to the apparent contents of the, according to the apparent, what is that? When I say tenor, according to the apparent appearance, you understand? According to the apparent appearance of the instrument, I found nothing, suspicious, and everything in the order I paid. But banker would be entitled to protection, because whatever payment he had made is payment in due course. you will be losing, Mr. Drawer. Therefore, don't lose. Better to cross. What is the objective of crossing? The objective of crossing is to secure the check as such. Okay, that's the main objective of crossing.